Morning, everyone. Now that we have quorum, and it's 1:03, I hope everyone can hear me. I call this meeting to order. Welcome to meeting number 23, the House of Commons Standing Committee on Industry and Technology, pursuant to Standing Order 1082 and the motion adopted by the committee on Friday, April 8th, 2022. The committee is meeting to study small and medium enterprises and competition. Today's meeting is taking place in a hybrid format, with some colleagues being here in Ottawa at the West Block and others on Zoom. For those who are here in person in Ottawa, you now know the public health measures that need to be observed. And I'm very happy to welcome witnesses who valiantly and graciously accepted to join us on this beautiful Friday afternoon. Thank you for being here. We have, as an individual, Jennifer Quaid, Associate Professor and Vice Dean Research, Civil Law Section, Faculty of Law, University of Ottawa. From the Automotive Industries Association of Canada, Jean-François Champagne and Steve Leal. Of the Canadian Health Food Association, Erin Skelton, Chief Executive Officer. Of the Canadian Manufacturers and Exporters, Matt Poirier, and finally from the Mississauga Board of Trade, Trevor McPherson, who is President and Chief Executive Officer. And I would like to make a note for MPs who will be asking questions that Mr. McPherson needs to leave us at 2 p.m. So if you have questions for him, please ask them first. So we will now begin with Madam Quaid. I hope I'm pronouncing your name properly. You have 5 minutes.
Okay. I wasn't sure if she was in the room, Mr. Clerk. So thank you for that information. Maybe we can just one moment. We'll just wait 1 minute. Are Mr. Champagne and Leal in the room? Yes, okay. Sorry, Messieurs Champagne, Messieurs Leal, je n'ai pas le loisir de voir ce qui se passe.
I'm sorry, Mr. Champagne and Mr. Leal. I can't see who's in the room in this hybrid format, but I will start with you while we're waiting for Madame Quaig. So we'll start with you. Thank you very much, Mr. Chair.
As well pour la période des questions. Alors, bonjour à tous. Mon nom est Jean-François Champagne. I'm the
Hello, everyone.
Automotive Industries Association of Canada, or AIA Canada, as we're also very well known. I'm joined today by Steve Leal, an AIA board member and the president of CEO of Fixed Network, a global leader in collision glass and mechanical repair services, operating over 2,000 points of service worldwide. AIA represents Canada's automotive aftermarket industry, an essential service industry which includes the manufacturing of replacement parts, distribution networks, and service and repair shops. We are responsible for keeping Canada's 26 million vehicles on the road in safe condition. Our industry is almost exclusively comprised of small and medium-sized enterprises. I'd like to focus my comments today on two key issues: competitiveness and labor shortages. And while this may be the substance of my remarks, we're happy to answer any other questions the committee members may have related to the items being covered in this important study. Canada's automotive aftermarket industry punches well above its weight when it comes to its economic impact. We employ nearly 500,000 Canadians, and we contribute $32 billion annually to the economy. Independent repair shops are in every riding across Canada, with nearly 25,000 facilities across the country. That would compare to about 4,500 automakers' authorized dealerships. These independent shops ensure that Canadians in every community, including small and remote, have reasonable and timely access to essential repair services for their vehicle. Despite a healthy numbers of employees working in the sector today, our members are worried about labor shortages and skill shortages. The need for qualified automotive service technicians vastly outpaces the supply. Automotive service technicians are one of the top 5 most in-demand trades in the country. To keep pace with the current demand for labor, in 4 years, Canada needs to certify 11,000 apprentices. Further, new technology in vehicles is creating a skill shortage. Modern vehicles are essentially wirelessly connected computers on wheel and service very much differently than their predecessors. To service them, Automotive tradespeople needs new skills and competencies. This is particularly true when it comes to electric vehicle, which requires skills related to high voltage systems and things such as battery removal. Skills training systems that exist today are not flexible and responsive enough to keep pace with emerging vehicle technology. Industry, with government support, can help raise awareness about how technology is changing the type of work that automotive tradespeople do. This, in turn, can help attract more students to the industry at a younger age and more people from non-traditional groups, such as women and new Canadians. Collaboration can also allow for more training that bridges the gap between what workers need, such as up-to-date equipment and tools, and what the current training system offers. AIA has been working with government and post-secondary institutions to provide this support and be happy to cover in the Q&As more specifically. Mr. Chair, we have people challenges, but we also have a policy challenge that is yet to be addressed by parliamentarians, and that is providing consumers with the right to repair their vehicles at the auto repair shop of their choice. Vehicles are increasingly becoming like cell phone, connected wirelessly at all times. Every new vehicle sold in Canada generates copious amounts of data on how the vehicle is performing. Increasingly, the ability to service a vehicle depends on an auto repair shops having access to this data. Currently, automakers, not vehicle owners, are the owner of the vehicle data. If our industry is to remain competitive, automakers should be required to provide access to this data so that consumers can continue to choose where they get their car serviced. Without intervention, automakers will continue to control the terms through which independent auto repair shops access necessary data. What this means for the potential shop, what this means is for potential shop closures, compromising thousands of jobs, and for consumer it means limited access and higher costs. The current voluntary agreement between automakers and the aftermarket work well for traditional cars, but not for modern vehicles. Consumer needs to be protected by legislations to reflect this new reality. And you should know that, more importantly, 83% of Canadians agree that automakers should be required by law to share data with independent repair shops. If you want an example of why we need right to repair legislation in this country, well, let's look no further to EVs, electric vehicle. The government has made it clear that accelerating EV purchases is a major priority in order to help reduce emission. Right now, our businesses would struggle to service EVs as the automakers have made it increasingly difficult for our shops to access the data they need to do so. EV adoptions, particularly on the scale desired by government, simply will not happen unless our businesses are able to service these vehicles. Lawmakers around the world have recognized the importance of the right to repair, including legislation that gives consumers the right to repair their vehicle. And Canada cannot afford to be left behind. Government must act quickly to advance right to repair principles through forthcoming legislation's effort. Addressing these issues will allow for small and medium-sized enterprises to remain competitive and continue to serve as the primary provider of essential services for vehicle repair to Canadians. Thank you for your time and looking forward to answering your question. Merci.
Merci beaucoup, Monsieur Champagne, très apprécié. Je passerai donc maintenant la parole à l'Association canadienne des aliments de santé.
Very appreciated. I will now pass the floor to Mr. Skelton from the Canadian Health Food Association. I think your microphone has not been activated.
President and CEO of the Canadian Health Food Association, I can tell you that our sector and membership are defined by small and medium-sized businesses that are dedicated to providing Canadian customers and consumers with natural, organic wellness products that help to promote their family's health. Now, our manufacturers, our distributors, wholesalers, importers, and retailers are in almost every community across the country. In total, there are over 2,800 retail stores selling natural health products, organic food, and wellness products in Canada, the vast majority of which are small and medium-sized business owners. Now, as we know, health is a top priority for Canadians. Now, in this context, a national survey we conducted found that 73% of Canadians used natural health products. Now, let that sink in for members. 73% of your constituents are using our products to promote healthy living. In other words, we are an important part of how Canadians maintain their health and well-being. Now, while we may be small and medium-sized businesses, collectively, natural health products contribute over $3.7 billion to the Canadian economy. Our members are very proud to employ over 55,000 Canadians across this country. So thank you for studying small and medium-sized businesses, as it is critical that parliamentarians understand the challenges our businesses face and the opportunities that lay before us. Now today, I want to highlight two critical federal government files that are of concern to our members. One is a significant missed economic and growth opportunity, and the second is an overburdening regulatory shift. On the opportunity side, I'd like to highlight the slow movement of the government to recognize CBD as a natural health product. CBD is the part of cannabis that does not get you high and potentially has a slew of therapeutic benefits. Now, since the laudable legalization of recreational cannabis, the sale of CBD products is only through recreational cannabis stores or through medical access with a doctor's note. Now, this makes no sense, as CBD, when sourced from a plant, is natural, and as a raw material should belong under Canada's established natural health products regulations. It is worth noting that regulating CBD as a natural health product was one of the options identified by the expert committee created to advise the government on how cannabis products should be regulated. The federal government has been inexplicably stalling on CBD policy, and it is resulting in a missed opportunity to create jobs and growth. This prevents natural health product businesses from capitalizing on the demand for CBD health products, and most importantly, is allowing an illicit market for CBD health products. Canada cannot ignore the economic opportunity presented by a CBD health product market. We urgently need to capitalize on our first mover advantage to the emerging global CBD market. Now, clearly, Canadians want safe and effective CBD products, and Canadian companies want to innovate and create jobs by providing a safe and effective products to consumers. It is the government that is standing in the way. In fact, a report from the Institute of Fiscal Studies and Democracies identified clear economic benefits of a CBD health product market. Now, the second issue is the government proposal for changing how self-care products are regulated. Our members are very concerned by the approach proposed by officials. These changes are being presented to industry with a piecemeal approach that will result in extensive financial costs and disruption to the entire supply chain at a time when the economy needs to recover from the impact of COVID-19. Now, what are the consequences of these piecemeal approach? Well, unnecessary financial strain on small and medium-sized businesses, higher prices on products for healthy families, a decline in product selection, and an increased environmental footprint. All things that I believe we can all agree should be avoided. So thank you for your time today, and I'd be happy to expand on any of these issues during member questions.
Thank you very much, Mr. Skelton. We'll now move to Mr. Poirier from the Canadian Manufacturers and Exporters. The floor is yours.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Good afternoon, everyone.
Here on behalf of Canada's 90,000 manufacturers and exporters and our association's 2,500 direct members to discuss the state of Canada's small and medium-sized enterprises. The manufacturing industry is 10% of Canada's GDP, produces 2/3 of Canada's value-added exports, and employs 1.7 million people in high-paying jobs across the country. Our association's members cover all sizes of companies, but the majority of them are SMEs. Actually, most of Canada's manufacturing companies are SMEs. Canadian Manufacturers and Exporters, or CME, has long been an advocate for addressing SMEs' various challenges. What differentiates CME from other associations, however, is our fundamental belief that the policy of the government should be to grow SMEs into large companies. Current government policy is not designed to achieve this end, but rather to keep SMEs small. In fact, 75% of Canadian manufacturers are small companies with fewer than 10 employees. In the US, just 58% of companies have fewer than 10 employees. While all companies start out small, and there's nothing inherently wrong with being small, size does limit a company's ability to attract workers, invest in automation or green transitions, expand production lines, and export. SME labor shortages and supply chain disruptions are two areas that illustrate how our disproportionately high rate of small companies acts as a drag on Canada's overall economic competitiveness. Take labor shortages. Manufacturers, big and small, are struggling to fill vacancies. And all this is happening even though manufacturing is one of the highest paying sectors in the country. But the smaller and more in need of specialized labor your company is, the bigger the recruiting challenge. In such tight labor markets, not being able to pay top dollar limits you even further. My main message here is that an SME manufacturer struggles more than larger manufacturers in getting the workers they need. This in turn restricts their business potential and hurts Canada's competitiveness. The second challenge is supply chain bottlenecks. Manufacturers are still struggling with disruptions, and again, the smaller your company is, the more pain you feel on the supply chain front. According to a CME survey, 9 out of 10 manufacturers report encountering supply chain issues. The added challenge for SME manufacturers with supply chains is their lower position in the pecking order for critical components. We currently have the situation in Canada where a company can have an increase in customer orders, a workforce ready to go, but nothing to build because they're waiting on parts. Parts their larger global competitors had less trouble securing. Again, because our proportion of SMEs is bigger than other countries, these problems ripple through the entire economy and hold us back. I'm happy to expand on these labor and supply chain challenges in more depth in the Q&A. But for now, how do we help alleviate these challenges and grow our SMEs so they can avoid these structural problems in the future? Number one, plug our labor shortage issues through immigration. Pandemic backlogs must be addressed, and we encourage the government to dedicate all the resources required to do that. We also must speed up the introduction of a trusted employer stream to the temporary foreign worker program. In time, we need to aggressively increase our intake targets to 500,000 per year in the economic stream alone. We need workers. Number two, provide financial assistance to manufacturing companies still feeling supply chain disruptions. Because our manufacturing companies are on average smaller than our global peers, we are lower on the priority list when it comes to getting short supply parts like microchips. We need to correct for this uniquely Canadian problem by bridging our manufacturers through these part shortages. And lastly, number three, make our policy be that we want to grow SMEs into larger firms. Tax reforms that cut costs to business and changes incentives to reward growth rather than company size is the first step. Implementing a patent box regime to foster commercialization of patents is the next step. And finally, provide more support to SME manufacturers, accelerate the adoption of automation and green technologies. By increasing the competitiveness and scale of manufacturing sector, we can better produce needed materials at home and reduce our reliance on foreign suppliers. While in the short term, we must address the many challenges facing SMEs, our long-term strategy must be to grow these companies. Thank you again for inviting me, and I look forward to the discussion.
Thank you very much, Mr. Poirier. I'll now move to Mr. McPherson from the Mississauga Board of Trade. The floor is yours.
Thank you very much, Mr. Chair, and thank you, members of the committee. On behalf of the Mississauga Board of Trade, thank you for the opportunity to appear before you on this very timely study on labor shortages and productivity issues faced by our small and medium-sized enterprises. I would particularly like to acknowledge MP Equinder Gahir for inviting us to be with you today. Since 1961, the Mississauga Board of Trade has been the voice of business in Mississauga with close to 1,000 members in virtually every sector of the economy. Mississauga is truly one of the most diversified urban economies in Canada. The city of Mississauga is home to Canada's largest international airport, Toronto Pearson, and as such contains most airport employment zone businesses serviced by most of the 400 series highways and both CN and CP rail lines. Mississauga, in many ways, is the goods movement and supply chain capital of Southern Ontario, if not Canada as a whole. Committee members will appreciate that labor challenges have long existed well before the COVID-19 pandemic and have simply been exacerbated by the situation. While there is no magic bullet to solve our labor shortages, which exists in both skilled and unskilled labor, The government should work closely with industry to consider new programs around training and supports, worker-focused immigration policies, and by working with the provinces, territories, professional and labor associations to provide for better recognition of foreign trained credentials and an efficient pathway for newcomers to bring their relevant skills and experience to where they are needed most in the labor market. Regulatory burdens and bureaucracy also play a role in the difficulty in recruiting and hiring new employees. The Mississauga Board of Trade sponsored a resolution before the Canadian Chamber of Commerce a couple of years ago, calling for an expedited review of the national occupation codes to ensure these match up with the realities of the job market today in Canada, and the need to include new categories to keep up with industry demand, technological advancement, and an economy in transition. There has been much in the news lately concerning supply chain issues, both within Canada and around the world. As a major logistics hub in Southern Ontario, we know firsthand from our members about this very significant challenge. Some of this, of course, is the marketplace functioning with impacts on production and transportation of goods stemming from a wide variety of reasons. However, government regulations and how agencies like the CBSA, Health Canada, and others operate can have the effect of slowing down effective and efficient goods movement and should be constantly reviewed by the government. Of course, current levels of inflation are a significant concern for the business community and small and medium-sized enterprises specifically. For many of these firms, the impacts of the pandemic are far from over as they struggle with all kinds of cost pressures on their businesses, not to mention the significant levels of debt that have been incurred as a result of the COVID-19 pandemic. The government should look closely at its own fiscal policies to ensure it is not adding to inflationary pressures through the impact that taxes, fees, and other charges have on the costs of virtually everything. We often talk about a competitive Canada that can compete and win in the global economy. There is much truth to this, and Canadian companies are agile and adaptable. At the Mississauga Board of Trade, we promote trade diversification and expose our members to opportunities in markets where Canada has a competitive advantage. Canada's free trade agenda should be applauded and aggressively promoted so that we see more Canadian companies successfully competing with the best in the world. We would encourage the government to review, modernize, and update the Competition Act, the Privacy Act, and any other regulations that hinder an open and competitive marketplace or permit frivolous cases to be brought forward by competitors. Together with a competitive tax regime, this would also position Canada to better compete with other developed markets for foreign direct investment, which in turn bring new business opportunities to thousands of small and medium-sized businesses across the country. There is no question that the federal government stepped up to support small and medium-sized businesses and their workers throughout the COVID-19 pandemic. However, I would be remiss not to emphasize that we are now in the so-called financial long COVID phase of recovery, and government must recognize the significant challenges businesses will undoubtedly face with debt repayment and a prolonged period in returning to pre-COVID-19 business levels in many sectors of the economy. Again, thank you for the opportunity to address the committee today, and I look forward to the question session.
Thank you very much, Mr. McPherson, and I welcome Madame Quaid to our committee. The floor is yours for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Honorable members of the committee, my name is Jennifer Quaid. I'm Associate Professor and Vice Dean of Research in the Civil Law section at the University of Ottawa. My areas of expertise are corporate law, competition law, anti-corruption law, business law, and general criminal law. I'm very pleased to appear before you today to discuss competition law in the context of SMEs. I will come, however, with a little background on competition law, and please note that I will be switching languages between French and English. I hope that will not be a problem for anyone.
To focus my remarks on the ways that competition law and policy relates to SMEs. In doing so, I will discuss the current amendments that have been put forth in the First Budget Implementation Act and how these may affect SMEs. I will also touch on the importance of broader reform to competition law and policy and the importance of integrating competition policy into a transversal approach to economic policy. Competition policy is a part of economic policy and as such should operate in tandem with other policies across departments and agencies in the service of Canadian society as a whole. At present, competition policy, and in particular the specific framework of rules that form the body of competition law, the Act and its legal interpretations, has developed largely as a distinct field. It has tended to have a small footprint, erring on the side of lesser intervention rather than more. It is built on a foundation of neoclassical economics, which assumes that, in general, market capitalism should be left to operate with as little intervention as possible. I am generalizing here. Where intervention is required, it should only be as little as possible to address the worst of anti-competitive effects that could have or might be caused. There are a couple of things that characterize competition law that are germane to the work of this committee. First, the purpose of the Act is not competition for competition's sake. The guiding principle is that competition is the best way to generate certain desirable benefits in society. These desirable benefits, which are identified in Section 1.1 of the Act, and other experts who've appeared before you have spoken about this, they include, and there are 4 of them, the efficiency and adaptability of the Canadian economy, expanding opportunities for Canadian participation in world markets, while at the same time recognizing the role of small and medium-sized enterprises, that they have an equitable opportunity to participate in the Canadian economy, and in order to provide consumers with competitive prices and products. There is much debate about the purpose clause and what goals are or are not identified in it. At this critical juncture in the digital transformation of society, the time is ripe to take a hard look at the purpose clause. Is it, as some have argued, an arbitrary and unworkable collection of aspirations that are largely incompatible? Does it identify too few goals? If so, what other goals should it expressly include? Would it be better to create a single statement oriented to the public interest? Or, as others have argued, should we just fall back on economic efficiency? I won't go over what other experts have talked about in terms of the debate over the purpose clause, but I think it's very important to consider the context of SMEs in the larger discussion about competition policy. The second point that's germane to SMEs in particular is that the Competition Act is a law of general application. This is typical of the drafting style we use in Canada. It is also characteristic of legislation that applies to business entities. However, the practice of using general rules tends to obscure important structural differences and economic realities of SMEs versus larger business entities. The sheer range and variation in models of business organization means that rules intended to apply equally, because it's the same rule for everyone, in fact produce profoundly different effects. I would be happy to expand on this in the question and answer period, in particular in relation to the pending amendments in proposed Bill C-19. Un troisième élément crucial, qui est
a third crucial element related to the previous point is that digital transformation has a significant impact on business practices, business models, and strategies for growth and innovation by companies. However, SMEs are experiencing digital transformation in a different way than large companies. Without overgeneralizing, it's important to recognize that just as there are power asymmetries between consumers and individuals and businesses and organizations, there's also an imbalance between SMEs and large-scale global businesses, particularly those that control virtual platforms and develop the information technologies necessary to access e-commerce and digital markets. The concentration of power in the hands of a small number of private actors, combined with significant gaps in the governance frameworks for various aspects of the digital economy and society, such as privacy rights, data protection, interoperability, the use of artificial intelligence in a growing number of areas, and the impact of social networks, creates a situation where the access to even economic participation can be restricted or subjected to onerous or even exclusionary conditions. I would just like to say a few words about Bill C-19. I'll speak as quickly as possible, but I'll be happy to answer questions if you want to know more about it. It's important that you pay close attention on the amendments proposed. Even though the budgetary process usually goes very quickly, there are important consequences for SMEs that will flow from the proposals, which are likely to be passed without amendment. I will be blunt. There's no doubt that the proposed changes to the Competition Act are substantive changes. They may be in a budget bill, but they're being proposed with a clear objective of initiating competition law reform. According to government statements, Division 15 is only the first draft of a two-stage reform. Division 15 is the preliminary phase. The second phase, for which we don't know a timetable, will be preceded by public consultation designed to sound out all interested parties on the role of competition policy in the 21st century, particularly with regard to the digital transformation of the economy and of our society. Of course, I would have more to talk about this, but it's all that I'd say at this point. However, I would like to focus on the proposed amendments in the bill. There are 8 changes. 4 of these are widely expected, as both Minister Champagne and Commissar Boswell had made specific reference to them in public statements over the last few months. These are, first of all, the addition of a provision creating an offence of conspiracy in relation to employment, the amendment of the maximum amount of certain administrative fines and penalties, the addition of a provision clarifying that the use of partial prices constitutes a false or misleading representation, which can be pursued either in trial court or in civil court, creating a private right of access to the tribunal in abuse of dominance cases. There are also 4 other amendments that maybe aren't surprising, but we weren't necessarily expecting to see them in a budget bill. These are amendments to sections 78 and 79, dealing with abuse of dominance and saying what is behavior that might lead the Commissioner to intervene. Also, the addition of elements to be considered in the determination of appreciable prevention or lessening of competition related to abuse of dominance, of merger and civil collaboration. The addition of a general anti-avoidance provision before merger, and also amendments in terms of obtaining documents in Section 11. According to the government, there is a consensus, at least among those who have spoken publicly, in terms of the consultation carried out by Senator Whetstone, to whom I participated.
Conclusions of these changes in the budget bill should not have been great concern, as few will disagree with them. I could not disagree more. While the Competition Act is in need of reform, and urgently, and for reasons related to SMEs as well as the economy in general, the budget bill process is unlikely to be conducive to a thoughtful reform, even on those issues that some may consider low-hanging fruit. It is important to modernize the Act, but if we do it poorly, without consideration of the bigger picture as well as the technical nuances, we risk simply changing the law without making competition policy any better. I have 2 more points and then I'm finished. I just want to highlight that there are 2 modifications in this law that concern me greatly. The first is the creation of the wage fixing offence, and I'm happy to go into detail about why I think it's highly problematic, especially for SMEs. And the second is the matter of the penalties that have been modified and the use of scalable penalties, but in a very limited fashion. And I think that there was an opportunity lost here to make the Act more aware of the differences between sizes in enterprise. I will just close by reiterating the importance of competition policy reform and that we need to do it well. This requires consultation from a plurality of stakeholders, notably owners of small and medium-sized businesses and all the people who are affected by this sector or who participate in this sector of the economy. We need to identify what values matter to us, what principles matter to us, and then we can decide how to change our competition policy. Half measures are simply not going to do it. Thank you, and I remain at your disposal for questions.
Merci beaucoup, Professeur Quaid.
Thank you very much, Professor Quaid. I think that Michael Graham has the floor for questions for 6 minutes.
witnesses for joining us today. Mr. McPherson from the Mississauga Board of Trade, I understand you have to leave early, so I may as well start with you. I'm paraphrasing here, but in your statement you said that the government should not add to inflation through taxation. Can you expand what particular taxes do you feel contribute the most to inflation?
Yeah, I think it was a general statement with regard to, as the government is considering any new measures that would impact small business, that they'd be keenly aware of the costs that would be transferred onto small business, and ultimately those costs are often transferred onto the end consumer. So it wasn't with regard to a specific tax per se, but it was just to be mindful that sometimes there can be unintended consequences, and it not necessarily tax. It could be regulatory based as well, because the time and resources required to meet new regulations can also add to business costs.
Okay, and yes, you also spoke about regulatory burden and bureaucracy, and you mentioned how your organization wanted a review of job classification categories a few years ago. Could you elaborate on what we would like to see there?
Right. So this is with regard to the transitioning economy, the new areas of jobs and skills that are required in that economy, and that the codes be reflective of the current reality. So it's all part and parcel of modernization efforts, and to be so that those occupational codes are in line with the jobs that we're seeing. If we think about various new elements of the economy, artificial intelligence, etc., there are a number of new occupations that are increasing in need across industries, and that those occupational codes that will inform things such as immigration, etc., are in line with the current realities of the economy.
Okay, and you also mentioned CBSA and how they can sometimes slow down the movement of goods across the border. Could you elaborate on what the CBSA can do better?
Sure. So I think it's looking at the processes that the CBSA employs. Sure, resources are also an issue. We're seeing it in terms of passenger movement, but it also affects goods movement. And quite frankly, there's a considerable backlog for many of our members that are either importing or exporting goods. And many of these being inputs into the final products that they are putting to market. And it's really a notion that we need to look at, beyond resources. Are there areas of duplication, etc., within that process? And we've all seen, what's happening for a number of reasons at just for one example, our airports, in terms of time delays, etc. The same thing is happening in terms of goods movement with regard to our ports of entry. So it's really a comment that we need to look at everything we can do to reduce duplication, to make the system as efficient as possible, especially as we're dealing with other pressures such as staffing issues, etc.
Okay, I believe you meant this as a rhetorical question. You said, are there areas of duplication? And so my question is, are there? Or did you have any specific examples of if we could just get rid of this or get rid of that or combine these areas? Do you have any specific tangible examples that would be beneficial to the committee?
And not at this point. I just think that it's important that this be considered as we're reviewing the needs of CBSA and the work that they do. Nothing. It's not a specific example that I'm bringing to you today.
Okay, thank you very much. I would like to shift gears to Mr. Poirier from the Canadian Manufacturers and Exporters. Mr. Poirier, you talked about incentives for automation. Can you expand and elaborate on what incentives you would find helpful for SMEs?
Yeah, in general terms, the incentives can, I'll pick one. It could be through the tax code. That would probably be the most helpful, right? There's a whole suite of programs that currently exist. Most of them focus on the big companies. So it's very challenging for an SME to sort of find a home in those programs. So it would be to expand those. Strategic Innovation Fund, for example, to name one. To have better coverage for the SME market. But also the big thing for SMEs too is it's great if the government has a program. It's very hard for them to know about it. It's not their natural instinct to say, gee, I wonder what the government has on offer for me. So the outreach component has to be a major part of that as well.
Thank you very much, Mr. Poirier. Monsieur Crum, je passerai maintenant la parole.
Mr. Crum, thank you. I would like to give the floor to Vivienne Lafrance for 6 minutes. Thank you, Mr. Chair.
Statement that you had further thoughts to share about wage fixing. So please go ahead and elaborate on these thoughts with the committee members today.
It would be my pleasure. I think that what's important to preface before I start going through this, because it can sound very lawyerly and picky, is that I think that we do need to address protection of workers, and we do need to think about the impacts of the way the new economy, and particularly some structural effects are affecting workers, plays out for them. I just believe that creating a wage fixing provision is not going to contribute to that. So what worries me is that wage fixing is being offered and being explained and justified as a way to protect workers. And the subtext, I believe, comes from the removal of hero pay that was coordinated between the large grocery players back in 2020. And that's a situation that's pretty unusual in terms of the typical kinds of cases that are looked at as wage fixing in the United States, which is pretty much the only place that does wage fixing criminally. And it's very recent, actually. And I guess my concern is that the criminal law was not designed to deal with unequal bargaining power or unfairness. And what is being criminalized is agreements among employers, not a term that is defined, with regard to fixing wages and with regard to no poaches, which is limiting mobility. And the way it does this is simply says, those practices in and of themselves are not a problem. So having low wages or restricting mobility is not really the problem. It's just agreeing about it. But the difficulty that even if you accepted that, okay, we want to go after employers who agree to do things together, is that the criminal law is not a remedial type of statute. So victims of criminal behavior have a very small stature in the criminal law process. And I have done a lot of research in corporate criminal liability, which is likely the area of law that will be brought into play because many employers are organizations within the meaning of the criminal law. And there's very little evidence that there's going to be creativity in terms of crafting restitution orders or corrective measures, even though those powers exist. And if it's just a matter of imposing a big fine, I'm not sure that achieves much for workers. I will tell you what my primary concern is for small businesses, however, is that these criminal provisions look like they're there for big companies. But the reality of criminal law enforcement against companies in Canada under the Competition Act, except for large international cartels, which are led by the United States by and large, and then we come in and tag along at the end, they're brought against smaller enterprises. And I worry that, in fact, the practical impact of this provision is that the most likely cases that might be brought are against small and medium-sized enterprises because it won't be possible to bring the cases, or it'll be a lot harder to bring the cases against larger enterprises. There are also a host of technical problems with this provision, but I think that my central concern is that this should be dealt with by labor law. And I don't understand why we think criminalizing, a tiny bit of conduct is going to do much to help workers. It rather creates it injects substantial uncertainty into Section 45, and I think that in the unlikely event that prosecutors actually apply it, because I think they will have all kinds of good reasons to stay away from this provision, largely because there's so many undefined terms and so many weird things about it. I worry that it's actually going to be applied against, not against the types of employers that maybe the public has in their imagination. But I'm happy to go on more if I think that's probably enough.
Well, I have limited time, and I would like to ask some questions about the digital markets. So through this study, we've heard from stakeholders that small and medium-sized businesses cannot take on adaptation to digital markets alone. They said that any further regulations are overwhelming and burdensome and greatly affecting their revenue, and some may not have the knowledge to join a digital economy, while others don't have the available labor. So how can SMEs be protected through the Competition Act from larger global organizations who have entire teams dedicated to their expansion in digital markets? How can we make it a level playing field for SMEs?
Well, I think that the first thing that I have to say is that competition law hasn't necessarily always had as a vocation to make a level playing field among all sizes of enterprise. I do think that's a legitimate question to ask. I'm not sure that that's going to be solved in small amendments to the Act. That's going to be part of a larger consultation. But on the question of what can we do now, I actually would flip the question around and I would say perhaps, lots of regulation about participation in the digital economy is not appropriate for smaller enterprises or needs to be rethought or adapted or simplified. That may very well be the case. But I actually think the greater problem facing small and medium-sized enterprises is that the large players, those who control what we call the digital ecosystem, they control the actual marketplace, they are actually subject to less regulation and governance than I think they should be. And I think part of the problem might be actually reining in the fact that most of the evolution of digital markets has happened in a way that is oriented towards private economic interest. And that's because governments haven't been present putting out the guideposts and saying there are limits to what you can do out here. And it's not true that regulation or governance is anti-innovation or anti-competitive. The evidence is very, very clear that you cannot draw a straight line there between, regulating. I think, however, we need to think about who we're regulating and for what purpose.
I'd like to ask, do I have time?
Madame Lapointe, je suis désolé, c'est tout le temps.
Madame Lapointe, I'm sorry, this is all the time you have. Thank you. Now I would like Mr. Lemire on the floor for 6 minutes. Thank you, Mr. Chair. Please allow me to speak to celebrate an important anniversary. For 20 years now, my colleague Brian has been an MP, and it's news that I heard with a certain interest. And so it means he's been on this industry committee for 20 years, so he really is a formidable veteran. And he acted as a mentor for me when I was a new MP, and I'd like to thank him for his work and his rigor. Mr. Chair, I also would like to take advantage of this time to respond to Ms. Quaid's call. The Finance Committee yesterday made a proposal that our committee study Part 5, so divisions 15, 16, and 17. And after having checked with the House, there was unanimous consent that we might be able to reflect on this question that was given us. So, Madam Quaid, you'll probably receive an invitation to help us with this. But I think it is the responsibility of our committee to look at this upon the invitation of the Financial Committee. Should I keep going with my questions? Please go ahead with your questions. I think that there seems to be a consensus so that we look at this file on Friday, but I will validate that before the end of the meeting, I assure you. So it's highly appreciated. So I'll ask my question to the Canadian manufacturers and exporters. So they're suffering from labor shortage, so they're employing contractors are being sent outside of Quebec, and so it's a problem in Quebec, especially in the context of the Buy American Act. This is added to another trend, which means opening establishments in the U.S. to respect the requirements of Buy American. So Merriman opened a outfit in New York to do this, and also AB Energy also told us that they did the same thing. So my question is, are the exporting manufacturers, do you have any sense of whether the government is taking this? So that's quite a few $billions in Quebec that leak out of our economy and can have an effect on our exporting businesses. I will answer in English to answer this question correctly.
Yes, the government is doing all it can on the Buy America front. The challenge that we know is that as the smaller country and the smaller economy, it's very hard to negotiate with a larger partner that holds all the cards. We are big supporters of reciprocity in government procurement. So, and we've armed ourselves with that tool recently in 2 budgets ago now. And that is something that we take very seriously, because if they are not going to grant us, the US, I mean, access to their markets, to their procurement markets, we have to be ready to deny them the same access. It's a frustrating situation to be in for manufacturers, because we would love to have just the free market. In fact, we're an integrated market. We don't really trade with the US anymore. We build stuff together. But unfortunately, if you don't retaliate, you run into the situation where it like you mentioned in your statement, where there's an incentive for a Canadian company to locate in the US just so it can have access to both markets and not vice versa. So that's why it's important to have that reciprocity.
Merci. Je lisais la...
Thank you. I was reading Véronique Prou's call. She directs the manufacturing exporters. How much money is the government ready to lose over the 50 years? How many businesses will have to refuse contracts or move some of their operations abroad before the government acts to redress the shortage of labor?
Of labor shortages in manufacturing is very acute, particularly in Quebec. We have 80,000 vacancies in our industry right now, and we're one of the highest paying industries out there. This is a problem that we need to fix. We think that we can do it through immigration, but we have to be a lot more aggressive. And kudos to the government for increasing numbers, but it's nowhere near what we need.
Les entreprises ont...
Businesses also need more predictability for their operations. The labor shortage is related to a typical image in my region. Has beautiful lakes and rivers, so we're saying it's impossible to catch a fish in a lake that hasn't been overfished or it hasn't been seeded. So we're saying the lake is empty in terms of labor shortage. I would like to quote Madame Proulx again, who's saying that governments feel left to their own devices with their problems of recruiting labor. And the manufacturers are hiring many temporary foreign workers, not just in the agriculture sector. Could you speak to me about temporary foreign workers? What measures should the government put in place right away so that we can respond to the problems of labor shortages? And I'd like to invite you to talk about the regulation challenges that exist, especially with the IEMTs.
On a lot more out of necessity by manufacturers, because there's simply no other recourse to get the workers that they need. So on that front, sure, there's always streamlining that needs to be done. There's to the program. They're currently trying to introduce a trusted employer stream. We need that yesterday. So our call is for that trusted employer stream to come online sooner rather than later, and for it to be a true trusted employer stream. If an employer has a demonstrated track record where they are not abusing the system, they are not displacing Canadian workers, they absolutely need this. They should be able to access those workers really quickly to help meet their labor needs.
Je vous remercie, Monsieur Poirier.
Thank you very much. My time is finished. Thank you. Thank you for your discipline, Mr. Lemire, to have followed your time. Mr. Monceau, you have the floor for 6 minutes.
Chairman Lemire for such kind comments, and just to this is a great committee to spend a lot of time on. It's very good. It's also in really good hands right now. Actually, for all the time I've been here, this has been actually a lot of fun the last number of years we've had in this committee. So just wanted to say that, because there's been times where Parliament doesn't seem like it's working, but it's really working well here. So my thanks to Mr. Lemire and the rest of the committee here. I'm going to move to Mr. Leal and Mr. Champagne, because we're talking about a lot of issues here in terms of shortage of labor and shortage of issues. Now, 12 years ago, I introduced a private member's bill on the right to repair. It eventually became a voluntary agreement, so it did actually pass Parliament to the final stages, and then it was withdrawn because then at that time, Mr. Clement was working in the industry and the association together, and we created a voluntary agreement. But it's 12 years old, and it also had the weakness in it that EVs and digital data was just emerging at that time. So we kind of knew that the agreement would have to have some type of modernization or some challenges with the digital work. But maybe you can outline a little bit too, is that what gets lost a little bit in the discussion is that that people just use as personal vehicle fixing, which is obviously paramount to consumer choice and all the labor you mentioned, but also too other vehicles like ambulances, police cars, fire trucks, other equipment that's necessary for our economy to function. And if we lose some of the service providers that you have, we're going to have massive gaps that will cause further labor instability and labor market inactivity because there won't be those professionals around to work on those vehicles. So perhaps you can touch on that, because I don't think it gets a lot of attention.
Yeah, hey everyone. You know, for myself, I'm hoping that at some point, at a time you guys use one of our services or franchisees from Fix Auto, Pro Color, or Speedy Auto Service. On the automotive spectrum for us, you know, when I hear everyone talking, you know, about the competition, small business, we're a franchise system. We represent small and medium-sized businesses. One of the big believers for me, I started with one garage and obviously grew it now to a point that we have over 2,000 locations, but mainly franchise. For us, if the right to repair, as you call it, from 12 years ago, we didn't have connected cars like we have today. So if you imagine these cars are connected, and it touches more than just on the right to repair the vehicle, but also if you imagine for everyone, the ecosystem touches so much more. So on the collision side, you get in a car accident, the data from when you get in the car accident all the way back to the insurance company, the whole ecosystem is being digitized, right? So the right to repair of information of this vehicle becomes critical, not for just repairing the vehicle. It actually comes from the insurance companies on how they regulate for insurance premiums. And also at the point is the OEs are the gatekeeper of all this data. So if I can't fix the car, I don't own the data, the customer doesn't know what data we're capturing on them, you're turning over a lot of what I call knowledge and power of that data. And I remind, data today is like the new oil in our industry. The data they want to capture is worth a lot of money. And for us as a government, if we leave it so open-ended, not just on the ability to fix a car, you can imagine everyone's familiar with some of these progressive OEs. The cases old agreement only involves the traditional manufacturers. But you have companies like Rivian or Tesla that are connected cars, they're electric vehicles, but if I have a Tesla up in Thunder Bay and I get in a car accident, for example, am I going to tow it all the way to Toronto to get fixed? And at the end, premiums go up, and then it affects every single consumer paying for that non-ability to get the data. These cars are connected. You can't fix it. They can actually software update and do things without us even knowing. So I think the whole ecosystem on the connected vehicle, the mobility of a car, that's something that created a new ecosystem that I think the Competition Act and certain things don't look at to make sure it's fair for everyone, that we have fair competition for everyone to access and ability to train and repair these vehicles. I think if we can't get access to the information, you know, it's going to be hard for us to fix.
If I can just interject, no, it's critically important, but also too is I think this is where I was trying to reinforce though, is that there's other vehicles that you're repairing other than personal vehicles in these shops, and so when those vehicles go down, the other parts of the economy then also go down. And I actually have a digital bill of rights, and I have reintroduced legislation on this to fix it and modernize it. But I don't think that there's, you know, can you kind of highlight a few of the other types of vehicles that you serve? Like everybody understands like there's the personal vehicle, but when I traveled the country on this, I didn't realize how many other parts of the economy are tied to what's happening in your shops because nobody else can fix those vehicles. If we lose those shops, other parts of the economy go down.
I would say one of the ones that I'm familiar with is we deal with Demir ambulances. So ambulances that are across Canada. In these local communities, they rely on our local garages to fix these ambulances, right? So we need to have access to make sure we can keep those cars on the road. We have available information, right? So ambulance is one that touches every local community that we do business in.
Yeah, and that's important. And as well with the are you still having some difficult getting some? It was a good point that you raised because like Tesla, it's an opt-in process, which is part of the failings of the current agreement. I have been talking with original manufacturers. They understand there's some challenges, and so there's some activity taking place. But right now, there's without legislation. It's ironic because in Point Pelee, I go there in my area. There's Tesla charging stations with the federal government that's allowed on site. Mind you, you can't charge other electric vehicles because you need an adapter. That's another ridiculous story. But at any rate, but meanwhile, they're not even opting into the current program that we have for right to repair. So, one arm of the government's doing a deal with Tesla on our park system for the environment, and meanwhile, they're not even opting in to actually be a fair player with everyone else.
Yeah, I think, listen, there's going to be new entries of new OEs coming in. People have their own self-interest, and these are big American firms, well-capitalized. And, our shops are small, medium-sized businesses, right? So, they rely on government to make sure it's fair and competitive for them to be able to fix these cars. And we have no way to fight against big OEs on protecting the information, right? So for us as small independent operators underneath the franchise system, we look for the government to help and support us on that.
And I know I'm running out, but real quickly, sorry, do I have one?
Considering it's your birthday, Mr. Motz.
Thank you, Mr. I'll be real quick. And you're not asking for anything for free. You want to pay for the software. You want to pay for the training. You want to pay for all the equipment and follow all the rules. Is that correct?
Yes, I think what for us is what we said is if we want to take the training and buy the equipment to fix the car, we want to have the right to fix the vehicle, right? So for us, no one's asking for anything for free. We don't want government to hand out to that point. Actually, our guys will pay for the training and access the information, but we don't want to pay 12 different OEs for 12 different fees. Yeah. It'd be nicer to have it centralized control for the information.
Thank you. Thank you, Mr. Chair, for your generosity.
Alors, c'est rien du tout. Je passerai maintenant la parole à Madame.
Now, I would like to give Madame Gray the floor for 5 minutes.
For being here today. My first couple of questions are for Mr. McPherson. I wanted to ask you, are you familiar with the Canada Digital Adoption Program?
I'm familiar with it, but I'm not an expert in it, no.
Okay, fair enough. Is that something that your organization has marketed or promoted, and have you had any feedback from your members on it?
Yes, I think it's fabulous. I think it's necessary. We are partnered through the Ontario Chamber of Commerce on the digital adoption program, and so I would encourage more of this. And I think it's also important from a standpoint of cybersecurity, and increasingly, this is going to be an area that SMEs need to invest in. Again, another cost for small and medium-sized businesses. But if we think about some of the advice that several experts provided with regard to being prepared for a pandemic, I think we're in a moment now where we need to heed the advice in terms of being prepared for cybersecurity attacks and those impacts on small businesses.
I think, just to clarify, are you referring to the Digital Main Street program, which is provincial, or the
Nope.
No, okay, so you're kind of putting that as part of that. Fair enough. I wanted to ask you next about, you had referenced tax increases and how those could kind of play through and potentially have unintended consequences. And I wanted to ask, I know that, within your membership, you've got a real mix from, winery representatives to food service and motel and entertainment and arts. And so with something like the excise tax increase that, first you have the manufacturer, but then it ultimately would go down to, either those restaurants or motels or ultimately to the consumer. So is that what you mean, that, with those tax increases, at some point along the chain, someone has to decide to increase the prices?
That's a great example that you're providing. The excise tax, and certainly our member, Arterra Wines, has been very vocal proponent of not moving to increase that tax. So yes, that is what I'm referring to. Any any new taxes and regulations that are introduced that put additional costs on small business that are already dealing with substantial amounts of accumulated debt directly affect their ability to compete and survive.
Great, fair enough. And I guess you could also use a similar comparison. Would you agree with the carbon tax too? Because then that's really just adding to the cost of all the costs for businesses, because a lot of what they're using is shipped. So therefore, all of the transportation costs, and again, it just kind of adds to the cost of everything at a time when a lot of small and medium businesses are really pressed with within their budgets.
That's true, but I would also say that our members are very much wanting to contribute to solutions for climate change. So I think it's just a matter of ensuring that we don't put our businesses at a competitive disadvantage through whether it be a carbon tax, whether it be cap and trade, et cetera. I think we just need to be mindful of the competitive context when it comes to competition, both within the country, but specifically with our competitor jurisdictions outside of Canada.
Yeah, fair enough. And of course, I was referring to like increases, right? So just those increases here, which might be proportionately different. Great, thank you so much. I'll now like to go to Mr. Skelton, and thank you for being here today as well. And I wanted to touch on the red tape issues your group has highlighted. So would you say in the present time that the regulatory environment in Canada is predictable and stable?
Yeah, no, thank you for the question. I think there is a predictability to what we have now. I think what concerns our members the most is the phasing and the rollout of what's been discussed in future sort of changes to the self-care framework. And it's the ability to predict the timing of those changes, the scope of those changes, and being able to plan your business accordingly. I mean, as I touched on, I think coming out of the last 24 months, there's a lot of concern for our small and medium-sized businesses on how to navigate what that uncertainty is ahead. And not having a clear roadmap and not having some predictability in when these changes will happen and how they'll be coordinated is definitely a concern to membership.
Great. I'll squeeze in one more quick one here. I know you've touched on Health Canada, but are there any difficulties in other departments that you've come across as well?
I would say the majority of what I'm prepared to speak to today is around Health Canada. I think our members, I mean, like some of the other presenters today have said, are firmly committed to working with different organizations to find the best outcome for both sides. So, specifically today, it's around Health Canada, and that would be our commentary.
Merci beaucoup, Madame Gray. Monsieur Skelton.
Thank you, Madame Gray. Mr. Skelton. Mr. Dong, you have the floor for 5 minutes. And
they have a great weekend.
And yourselves as well. Thank you so much.
Thank you, Chair. My question actually was for Mr. McPherson. If you can stay for one more minute, just want to quickly ask you about. So you mentioned your member were using the federal assistance program during the COVID, things like CEBA. Most recently, I think HASCAP from BDC that helps highly impacted industry like tourism industry. Just for the record, are your members familiar with these programs or have been using these programs to support their business?
Absolutely, they have been using those programs, but that's not to say that they haven't still accumulated debt with regard to whether it be the Canada Business Account loans and other things like that.
That was going to be my next question. So let's take CEBA for example. We know that it's interest free. You pay portion back starting I think the end of 2023. What kind of feedback you've been getting from your membership? Let's say on CEBA, the portion that they have to pay back.
Well, certainly, I think that the extension of the payback period was welcome, but I think that the government should look at and perhaps you could look at those highly affected sectors, particularly in ways at how to alleviate some of that sitting debt for these companies that are hardest hit. If I think back to the last quarter, Statistics Canada noted an increase in insolvencies in the last quarter of 21, and we, quite frankly, our businesses are pressed right to the limit when it comes to our small and medium-sized businesses, particularly in these sectors that were very much customer facing. Hospitality, tourism. We all know what's been happening there. So I think that anything that the government can do, whether it be waiving of interest, whether it be some forgiveness, I think that those should be looked at because small and medium-sized businesses, as we all know, is where the growth comes from. We've heard from many speakers today that talk about the percentage of members that are small and medium-sized businesses. That should come as no surprise because we are a country that is largely our growth is driven from small and medium-sized enterprises. That said, I think there's something to be said about the larger anchor enterprises that bring business to those small firms. So I don't think you can look at the SME community in isolation. I think you also need to look at those policies that incite investment in Canada as well, and ultimately lead to opportunities for small business. So,
and I really appreciate your participation in today's session, and the committee is a public forum or a public platform for you to broadcast some of these thoughts. You said that you want government to play a more role in helping SMEs coming out of the pandemic. What roles do you think the large financial institutions should play, including the commercial ones, including the public ones like BDC? What role do they have in helping the SMEs?
Sure. I mean, I think that they play a significant role, and in particular, a lot of their role goes beyond straight up financing of companies, but they play a significant role in terms of an educational role that I think the government should look at other ways to partner with these institutions to provide them with additional knowledge and tools that help them manage their current financial situation. So I guess I would say that we certainly partner with institutions like BDC, and BDC is as a member of my board, in bringing knowledge and expertise in this area to our SME community. So I think they're certainly a vital partner.
Thank you so much. And I want to ask the same question to Mr. Poirier. What role do you think the large financial institutions, commercial and public, should play in the economic recovery and support of the SMEs?
I think they're playing it right now. What I mentioned in my remarks was the unique problem that SME manufacturers are having when it comes to accessing key components, right, to their process. When they talk to us and talk about these problems, it's because they can't get it, they can't produce, and they can't operate, and they're terrified of having to shut down and lay off their workers. So their solution is not to get a loan from the bank. It's more, how do we bring back the wage subsidy program that helps them keep their people on the payroll and keep them paid even if there's no work. So that's how they view this problem. They don't have trouble getting money from the bank, but that's not basically, that's not the issue. It's that they have to lay off their workers temporarily until they get the parts so they can start production again.
Merci, Monsieur Dong, je suis désolé.
Thank you, Mr. Dong. I'm sorry, that's all the time that you have. I know it goes quickly when you're having fun. I would like to give Mr. Lemire the floor for 2.5 minutes. Thank you, Mr. Chair. I'd like to go on with Mr. Poirier. You know that in Quebec, our manufacturing universe has 3,000 SMEs with 10 to 500 employees. So they are now at 44%. And there's an increase of 36% of jobs to be filled, an average of 12 positions to be filled per business. So there are 30,000 positions to be filled, never seen before. And I asked the question in the House, and the parliamentary secretary said the government's proud because they accepted about 100,000 requests last year during COVID year. But we see that the applicants have increased exponentially. So the labor market studies, impact studies, is a outdated study, and it really slows down everything that happens for businesses who want foreign workers. So that's information that the Quebecers are getting through the labor market partnerships. Do you think it's time to abolish the need for an LMIA in foreign workers?
The program, for political reasons, and rightly so, does not want to displace Canadian workers who can fill these jobs. But then we look at it as an association and as an industry that sees 80,000 vacancies, 30,000+ in Quebec, and we say, why are we doing labor market impact assessments to get foreign workers? So it's something that, if not abolished, can be streamlined to the point where, look, your sector is in desperate need of workers. I think we've proven the point that we can't hire from within. And that we need these foreign workers. So whatever means we can use to help speed and expedite that, we support it.
And I think that the manufacturing sector and the experts sector is an example where we don't need to find that evidence. So I'm interested in the price of production that's increasing because of Russian sanctions. Should the government compensate farmers for the increase of 35% costs with surcharges on fertilizers? Would there a question? Should one think about that?
It's hard to, obviously manufacturers are feeling the pinch from the sanctions, and it's not that they don't support them, they do. We understand the global crisis that we're in and the immoral actions of one country, Russia, in all of this. For the most part, manufacturers support the sanctions, but it doesn't mean that it doesn't come without a financial hurt and cost to them. For the most part, they're sort of dealing with it right now, but as time goes on, that pain will be felt, and it will reverberate through into jobs and to production. So, maybe the longer we're in it, we will have to start seriously looking at financial assistance. Are we there yet? It's because it's still, just a few months old, that everyone's still sort of reacting to it. But in terms of support of them, they are. But again, it comes at a cost.
Merci, M. Poirier.
Thank you, Mr. Poirier. Thank you. Mr. Mass, you have 2.5 minutes.
Friends of Canadian Manufacturing Exporters. I always remember, he's passed away now, but Congressman Obastar, Democrat from Michigan, he was actually the ranking member for transportation many years. He always advocated to me for us to actually push Buy Canadian so we can negotiate back with the United States, having a seat at the table. What I'm worried about is, as we kind of go down this road, is that how inefficient, because like a minivan made in Windsor crosses the border several times. Like it doesn't get built and then sent over one way or the other. It gets built by going back and forth, the engine, the parts, all that stuff. And I'm just worried about our inefficiency to compete with the East and the West going into Asia and other markets if we have this inefficiencies in our structured chain. Thoughts on that?
Absolutely. You know the system very well in terms of the manufacturing of auto. It makes no sense to us. As I mentioned earlier, we don't really trade with the U.S. anymore. We produce stuff together, and it does cross the border that number of times. We have, in our messaging, certainly we echo that. We say, look, we shouldn't be fighting amongst each other. The real competitors are China and other countries that are not necessarily our friends on a trade and manufacturing front. Within NAFTA, the new NAFTA, there's the competition chapter that was included on the insistence of our industry and our partners in the US. And we envisioned that at the time to be the mechanism through which we can sort out these differences and how we can leverage the trade agreement to coordinate and to compete against the East and West rather than to fight amongst each other. I don't know. I'm holding my breath to see that chapter used properly, but also the challenge, of the Buy America. It seems like we're not convincing the right people.
Yeah. Real quickly, Ms. Quaid, your testimony was excellent. It frustrates me, though, because how do we deal with, though, bread price fixing and then the wages? Like, there can be almost collusion by lack of competition. How do we deal with that? And so I understand that we do want to help the workers at the end of the day. So, but if we do nothing, is that also not an incentive that we don't have a stick on the companies that are behaving badly? Not everyone's doing that, but some of the stuff is just outrageous.
I agree with you that, we cannot ignore egregious behavior. I think it's just that one has to remember that, criminal enforcement, especially in the competition space, is rare, and it mostly proceeds through the immunity and leniency program, and these end up in deals. And increasingly, actually, there are also, although competition offenses are not eligible for remediation agreements, the first of which was just negotiated in Montreal yesterday, there's a workaround that has been developed under paragraph 2 of section 34. So I think that if people are imagining they're going to see people, I'm sorry to caricature, but executives in handcuffs going to jail, that's not going to happen in Canada. It's never happened. But I worry that, if we hang our hat on that and we don't do the hard work of talking to the provinces, of figuring out how do we create a framework where we support workers in this new economy, that this is just going to sit there on the books. And I worry about criminal provisions that are just added because everyone seems to dump big, complex problems into the criminal law, and then they get upset when it doesn't work. So that's my frustration. But I absolutely agree that some egregious behavior could be dealt with. I worry about how this provision has been structured, and I think you need to ask some hard questions about whether the prosecution service has some opinions on this, because I suspect they do.
Thank you, Mr. Chair.
Merci beaucoup, Professor.
Thank you, Madam Professor. Now I'd like to give Mr. Généreux the floor for 5 minutes. Thank you, Mr. Chair. Thank you to all the witnesses. Madam Quaid, I will continue with you, and I'll be more general. So there's the Rogers Competition Tribunal has to decide, and I'm listening people in the automobile industry, all the GAFAs in this world that are accumulated data about us. So it's a broad question, but I'll give you all the time I have to answer. Is Canada behind? And if that is the case, where should we accelerate the changing of legislation in order to be up to date in terms of this issue of data? Data is already the new gold of today. So how do you perceive that? You talk about C19, Division 15, and other acts. What should our priorities be in Canada currently? Thank you very much for this question. I think you're really asking the right question. What we have to ask ourselves is this broad question: what do we want to do? How do we want to situate ourselves in this new economy, this new society, which is now characterized by all sorts of things that have been mentioned? We use the word digital, but it's more than that, and I'll just leave that there. But you understand that the phenomenon is much more complex. I think that Canada is behind in more than one way, at more than one level, but we're especially behind because we have not initiated this conversation that must be had, and that's why I referred to the need for a transversal approach to respond to the digital issues. Digital is the economy. Society is connected. We can't separate these things. So that's the first step, and that's why we're waiting impatiently in my field of competition, but in general, for these consultations on the modernization of the Competition Act, because we have to see what are our values, what are the principles, what are we going to use as a basis to build this architecture, and then we will be able to go forward. The Europeans focused on this. They're very strong in terms of human rights, the dignity of the person. They talk a lot about consent and the autonomy of individuals, and all of their legislation, all their rules really progress. There's the Act on digital markets, on digital services, on artificial intelligence, on data, and also with the general regulation on data protection, but that gives them a theme around which they can organize all of the legislation. The Americans adopted another approach, and I think it's important to underline this because we have resemblances with them. We're a federation, for example, and they wanted to adapt the mandates of the agencies that are involved, and these are especially agencies traditionally associated with antitrust, FTC and the Antitrust Division of the Department of Justice, that have the mandate of coordinating and of setting out policies in that matter, even though other agencies are involved. So we're behind in terms of the general reflection, but also in terms of building an architecture of governance. Our Privacy Act is 20 years outdated. We have no law on artificial intelligence. We've just created a data commissioner. We don't know what the relationship will be with the competition commissioner and the privacy commissioner. I think we really have to sit down and discuss what we want to do. That's where we're behind. It's really to initiate this work on the foundations, and it will be difficult. We'll have to make compromises. We won't all be happily singing together. There are difficult choices to be made. We have to make them. We have to identify our priorities, and then we create the governance architecture that goes with this. And so what are the threats? One threat that I see, well, there are many of them, so we will be at the mercy of everyone else. I'll give you an example. For many issues in competition that involve digital giants, we must have international collaboration. And if we arrive at a table with the Americans, the Australians, Europeans, the British, that are all well ahead of us, and we say, well, we want to take part in this discussion, but they'll say, what are your rules? What are your priorities? Well, we'll be there, and we won't have anything on the table because everyone has to make compromises in international collaboration. But generally, if we've done the work of identified what's necessary, what's specific to Canada, so what's non-negotiable in our regulation, we're better positioned to say, well, here are our rules. We're ready to make compromises on this, but not on that. I'll give you an example. For example, protection of Canadian culture or linguistic protection. That is non-negotiable. But we have to have made that discussion, had that discussion. Otherwise, we'll just be takers, receiving what others are saying and subject to political compromises and the rules of other jurisdictions. Even though that's wonderful for them, it won't be good for us. So you don't want us to do a copy and paste of what's happening elsewhere. No, not at all. And we can inspire ourselves from what they do. And you have to do that. We have to look at what they're doing, but we have to really recognize that's the hard work, is to not do copy and pasting. We have certain realities here, and we have to take ideas from others, but adapt them. Thank you very much, Professor Quaid and Mr. Généreux. Now I would like to give the floor to Mr. Erskine-Smith for 5 minutes.
I'll stay with Professor Quaid because you've just articulated the need to be on the same page internationally, and yet you've expressed some skepticism about the wage fixing rule. But the wage fixing rule would bring us in harmony in a more serious way with our American allies, for example, where when we experience the reduction of wages of employees at grocery stores in the middle of a pandemic, if that had happened in the United States, the competition commissioner would have in the United States would have had a lot more to say than our competition commissioner was able to, and that's because of the nature of their law versus the nature of our lacking civil remedy, I would say. So how do you square the need for harmonization, but then to say, but I struggle with this kind of harmonization?
Thanks for the question, and I think it's really important to put a few things down on the table here. The American approach to criminalizing buy-side cartels, in particular wage fixing, is pretty much unique to them. Okay? We don't have other jurisdictions that have criminalized. In fact, there are very few jurisdictions in the world that use the criminal law in competition. They use civil remedies and other ways of going about it. So what the OECD says is we need to take cartels seriously, but we're not dictating the way you go about it. So that's the first point. And we do have already a civil collaboration provision in the Competition Act. Now, I will readily recognize that Section 90.1 of the Competition Act is a provision that requires a proof of a substantial lessening or prevention of competition and allows for taking into account efficiencies. So it is subject to the efficiencies defense, just like merger review is. And that is in some ways a weakness because and I think that's part of the motivation for creating paragraph 1 of section 45, that is to say to create a per se offense, because then you don't have to prove anti-competitive effects. And I understand that reflex.
I take your point, and maybe we are in agreement in some ways, because I don't need it to be a criminal offense, but the lack of a per se offense, the need to substantiate in some significant way, when the indicia that we see here of there's no other reason for them to communicate on this issue at all, other than to lessen wages in this particular instance. On a per se basis, there should be an investigation, and it would have happened in the United States, but we didn't see that because the law was insufficient for purpose. So your issue is more with the mechanism of the criminal law than to say we need a stronger remedy on this particular subject.
Following way put on the table that the Americans, it is far from clear that wage fixing is going to be a slam dunk. So far, we have preliminary decisions. They are not in sectors that are analogous to what happened here with the hero pay, something that I think could have been coordinated without communication, and that's something we have to realize. When you have strong market players in, a few dominant players in a market, it's not that hard necessarily to pick up signals without communicating directly. So that I think we have to put that out. But the Americans, it's far from clear. They are going on the basis that the Sherman Act has always prohibited buy-side cartels. There is a fairly strong opposition to that on the part of those who are being accused. So we're not at the stage where I say we have a ton of evidence. They're talking strong talk, and I'm not disagreeing with them on the principle that, if there's deliberate attempts to fix wages, that isn't a bad thing. But I really wonder whether we're going to see that. It's new. The memo that came out in the United States is from 2016. So this is not actually the area I think we're out of step with the rest of the world. I think we're out of step on a lot of other things. But I think wage fixing, we need to take a serious look. And I agree with you that, there can be serious conduct and it can be a problem, and perhaps exploring a civil remedy might be a good idea. But I wonder whether that's actually the problem that's being put on the table. I worry that we're making a promise about solving a problem that, in fact, this is not the problem that can be solved by the criminal law. That's my first worry. And the second thing is we have no basis in Canadian criminal law, Canadian competition law, to use a per se basis in civil matters. And I think you will find howling opposition to that.
Yeah, I understand. Well, except that, and I guess what I would put back though is there's no way they would have communicated at all had the proposed offense been on the books. And I take your point that you can still have signals in the marketplace that they might have gotten to the same place, may or may not have, but we wouldn't have seen, I think, the egregious conduct of CEOs directly collaborating on a subject that they had no business discussing. And I guess with the remaining time and the efficiencies defense, that is an area where we are out of step. And would you say in the next level of review that we're going to see on the Competition Act that we should seriously reform that particular provision?
Well, now you're asking for my position. Clearly, I have never been a fan of the efficiencies defense, and I guess I've held that opinion for a long time. I was a junior lawyer on the propane case way back in the day. So I have fairly strong views on that. Not everyone agrees with me, and I think you will find that it is an extremely divisive issue between the different sides in competition. I believe, however, that it's not my view that should prevail, although I will forcefully make the arguments I can. It really has to be a decision that's made on the basis of what values we want to promote. But right now, the way competition law is structured and the way it has been interpreted, I think that's the most important thing, because none of this is really written in the Act that way, has the effect of really putting a lot of emphasis on efficiency gains, and particularly the burden on the commissioner in terms of, providing quantification of anti-competitive effects. And the way that the efficiencies defense has been applied, it has become a trump card. And I think that really needs to be revisited. I think everyone agrees that the efficiencies defense has gone to a place it shouldn't be, but there is profound disagreement on whether we abandon it completely, even though you are correct, the only jurisdiction in the world, with a developed economy that has this provision.
Okay, thank you very much, Professor Quaid and Mr. Erskine-Smith. We'll move now to Monsieur Deltel pour 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. So to join myself in recognizing the quality of our witnesses. It's very impressive. Professor Quaid, I'd like to continue the conversation that began, especially with the questions of my friend Bernard Généreux. If I summarize what you said we're behind. Well, it's never too late to do things well. And there are two models in the world, the European model and the American model. Thirdly, we have to find inspiration from these models, not necessarily stick to one rather than the other, or more than the other. So I have a question for you. When our great economical partner is the U.S., would it not be better to align ourselves more with the Americans than the European system? What would be the best inspiration from one side and the other? Thank you for the question. These are excellent questions, and you've summarized what was said better than I did. To answer your first question, yes. I think not just because the U.S. are our primary partner, but because we have a lot of resemblances on the structural and political side, even though we're not identical. So we should look what the Americans are doing in competition. We've always tried to be aligned with them, especially in terms of mergers, for example, even though it's not exactly the same. But I would say that Americans do recognize that there are 6 bills before the American Congress. President Biden decided to spend his political capital to make progress in that regard. I don't know if these bills will be adopted, but the Americans are recognizing that there are things that must be added to their legislation. The other thing I want to add is that the Americans have not so far been able to create laws about certain aspects of the digital realm, but not because they don't want to do it, because it's impossible for them to do it. So there I would take a page from the Europeans to say, well, it's good to think about things ahead of time and have a more organized structure about the major principles concerning the right to privacy, interoperability, issues with intellectual property. So I think it's important to look at what's happening in the U.S., and we try and be harmonized with them without adopting all their weaknesses at the same time. But so we need to have, for example, our Competition Act is much more detailed than theirs. I don't know if you've read the Sherman Act. It's very vague. It would never be adopted as a law here. So we have to know that we need more legislative structure, but I know that we need to do more. The negative aspect is that our competition agency doesn't have the same weight or the same funding to achieve these major objectives. And I think that if we're serious, we have to really review the funding of the Competition Bureau and also ask to them certain powers in terms of investigation, and in terms of the digital sector. It would be good that they could study phenomena. They have a digital sandbox, but the capacity to go make people give them the data on what's going on, because we don't necessarily understand what's happening. So it would be important to give them the resources and the powers necessary to execute their mandate, as does FTC and the Department of Justice. So among the parallels between Canada and the U.S., well, you said it's a federation. We have provinces. So I'm attentive to what's happening in Quebec. Minister Leclerc filed some laws related to this. So are you concerned that we're having problems between provinces and the federal state currently? Well, there's a danger of doing this, that's for certain, but I will say the following. To my mind, the management of the economy, the economic policy and competition policy is a part of this. I think that we have to start looking at a collaborative approach. I know that that may be completely unachievable, But as for the environment, because in the end we realize that we can't do everything at one level of government, it takes collaboration. The issues are too important. And I think that we could even think about competition authorities at the provincial level that would collaborate with the federal government. And I think we're getting there. There was always a problem of qualifications, of competencies. There will be some overlap, but in other sectors, the two levels of government can work together. So it seems to me that in the interest of the citizens of this country, we should find ways of collaborating. So that would be my vision, to consider the possibility of more collaboration, even if it is difficult. Thank you very much, Madam Quaid. Mr. Fillmore, you have the floor for 5 minutes now.
Mr. Chair, and thanks to the witnesses for sharing their time and excellent testimony today. I'd like to direct, to start anyway, my questions toward Monsieur Champagne and Mr. Leal. And the questions are going to be regarding the right to repair. I'd like to explore two things. The first is sort of the broad question of how can we balance consumer rights while still trying to encourage innovation and protect IP. This is sort of the fundamental tension. And I wonder if from the perspective of your industry, how you might see that playing out and what government can do.
So, in my view, if you think about it, some of the arguments we've heard, different areas around the world, people using the opportunity and saying the day they want to protect IP. I think for us on the service side is, we're not against them protecting their IP. It's sharing it in a way that we can have access to the information to making sure we can fix the car, right? So I don't think we have a concern of them protecting IP. That's never been onto there. I think there's ways of delivering portals or data that's protected that we can share and people will get access to. So I would say, in our view, the problem is a voluntary agreement, unless they get legislation of government to force the OEs to put all their information in a trusted resource that is managed by industry and people are paying for it. So we're not asking for government to sponsor it, but basically to give the structure of what it should look like to protect their information, at the same time providing the information to people that need to fix the car. So I think, creating that portal of sharing collaboration, and I think it makes sure that we get the right information to fix the car properly. I'll pick on, we always look on the mechanical side, but I'll pick on the collision side. If you look on the collision side, when I have to repair a car that's in a car accident, I need to know a lot of information to put that car back on the road. And majority of the dealerships in Canada do not have a body shop. They use the aftermarket. So they need to work with us at that point, and we need to have access to the parts and the information to properly repair the vehicle to put it safely back on the road. So, I think, and when you look at the whole segment, mechanical is one piece, collision is another, and the other one is glass. You change a windshield now, you need to have ADAS calibration. And the OEs need to make sure they share the data on the vehicle to make sure when I recalibrate the camera that the car doesn't go in the wrong lane, right? So right. I think it's happening so fast, and every car now has calibration coming out of it, off the line, but the aftermarket and even the dealers, no one's up to speed yet.
Okay, all right. There's a constituent of mine in Halifax who I've known for years and years, and he's always worked on his own cars, going back to Cutlass is from the 70s, and less he's able to work on his own car now. But he did order something from Amazon in the United States it's the thing that lets you read the codes off of your car computer. And where does that lead to? I don't know. Consumers, the guy in his driveway with one of those code readers trying to fix his own computerized car. It probably doesn't lead to a good place. So there's something that we need to change here. If I have a minute still to go, Mr. Chair, I wanted to flip over, to trade agreements that we have. Well, I'll just stick with the United States, for example. Some of the technological protection measures, the TPMs that exist in these cars are the CUSMA, for example, has something to say about those. And so, here in Canada, we're trying to figure out something about right to repair, but it's going to have implications on trade with the United States. And as we know, the trade issues are fraught with the automobile industry. Any reflections to share there, how we might navigate that trickiness?
Maybe I'll just point out that, in fact, as we pointed out earlier, I think we're a little behind. If you think about from the perspective of the American, they already have right to repair legislation, which was extended to the connected car through the state of Massachusetts. You currently also have at the federal level the Repair Act, specifically looking at right to repair for the automotive sector. That's in front of Congress with bipartisan support. And so, if in fact we're going to be continuing to be able to have a good trade with our U.S. partners, we're going to also have to consider all the current legislations tabled in the U.S. that are again ahead of Canada in that regard.
Okay, so it sounds like you're holding up the United States legislation as an example for us to go by and to look at. Okay.
Yeah, absolutely. If you look at the state of Massachusetts, there was a ballot measure that was adopted as part of the last federal election in the U.S., which got broad support from the population. Again, 75%. All the counties throughout Massachusetts voted to extend the right to repair legislation in that state to extend to the connected car. And so that's a great example to definitely look at. But also I would encourage parliamentarians to also look at the federal act currently tabled called the Repair Act.
Okay, thank you for that. And safe to assume, are we done, Mr. Chair?
Yes, we're out of time, Mr. Fillmore, but thank you very much. We'll now move to Mr. Lemire pour 2 minutes 30.
Merci, Monsieur le Président.
Thank you, Mr. Chair. First of all, thank you, Madam Quaid. And I think you really are helping us to be like in a chess game to look at what's in the future. But I'd like to hear you talk about the consequence of not acting. Do you have any figures you can give in terms of the consequences for our businesses, but also for Quebecers and Canadians, the consequence of inaction or non-action? So we're talking about figures. Well, I'm a jurist. I'm not someone who studies impacts in depth. It would be interesting to know this, but the more time passes, the longer you have a situation of uncertainty, because the other countries are starting to situate themselves. We're still in a period of vagueness, and I think there's still a way to catch up. But they already have, there are already a few links ahead of us. And I think it's also true for the SMEs, not just for large businesses. More and more, we have access to the entire world for our business. The fact that we don't have clear rules here, for example, in terms of data management, what rules govern access to personal data, privacy, what are the expectations in terms of abuse of position of dominance in the markets. So the longer this uncertainty endures, the more it can have an impact on the capacity of our businesses to be on an equal footing with their international peers. So that has a cost, but I can't give you a figure for that. I don't think it's yet really major, but it's like when the Europeans came with their regulation on privacy, and everyone said, well, you can't do this, I'll never do it. And all of a sudden it's become the norm. So we'll be there once all the major decisions have been made, and we'll just have to put up with the decisions by other countries. So did some countries fear action more than others? Well, it's not that they're they have ill will, but they have different principles. So competition is created. Their competition law wants to serve their market, and the U.S. have all the digital giants. They have to manage with that situation. It's not that it's bad. It's just not adapted to our reality as a small country that's focused on international business, but with a SME sector and a small population. We really have to do this as a function of our reality. So I can't give you details. Research needs to be made. Well, we will do them. Thank you. Mr. Mass, you have 2.5 minutes for the final round of questions.
So the U.S. was brought up by Mr. Fillmore, and it's important because actually that's what started my passion in this over 12 years ago with regards to right to repair, is because you could, because of the U.S. laws, I could get a vehicle fixed in the United States, but I couldn't get it fixed in my own country. And, so that's, but they're looking at refining those elements. As for the current voluntary agreement, is there any way to modernize that? Because there's a private members bill the Liberals have in terms of right to repair. The problem with it is it's very wide, so it's not necessarily a problem. It's just that it's the way it's structured, and each province then has to decide its own fate on different things. Whereas automotive, we want the same standards across the board, especially for manufacturing and so forth. Is there any way to modernize the current agreement to strengthen it to be, you can't opt out, and second of all, to provide the proper oversight to ensure that it includes digital information and EVs and further enforcement?
I guess it will be hard to have a voluntary agreement that would say you can't opt out. So that the very nature of the voluntary agreement makes it so that the like of Tesla, who is a very different model, different business model, have chosen not to participate. And what we see in the future is that most of the new entrants in the EV space specifically are going to be non-traditional automakers who are not bound by the voluntary agreement. And their business model is very different. So I think we're going to see a model where without legislation, we're simply going to be able to have compliance to those kind of traditional voluntary agreements.
Yeah, I'm like, I don't like being proven right, but because we're kind of back at that spot. But we're also, it's a public safety thing too, because now we're going to have vehicles that will be on the road longer in more distances that read upgrades and improvements. And then some of them, as you mentioned, cameras and other things like that are actually, they're co-piloted now by your, the entire, operations. So.
Yeah, I think, listen, repairs are more complex, right? They're more computerized, right? You plug into these cars now, you need the access to the software and the data, or you can't access what needs to be repaired on the vehicle. So the data in the automotive sector, like I said, is going to become key for us, I think, in the future.
Thank you, Mr. Chair.
Thank you very much, Brian. So that concludes our round of questions. I want to thank our witnesses for joining us today. It's been, again, a very interesting meeting. So thank you for your knowledge, for sharing your knowledge with us. And I wish you all a great weekend. Before we adjourn, members, we have a bit of committee business to discuss. So for those joining us, for our witnesses online, you can log out if you so choose. And thanks again. And so just colleagues, we've received an invitation from the Finance Committee to look at sections 5, 15, 16, 17 of the BIA. We've had discussions, and Mr. Lemire brought it up earlier in the meeting. We've had discussions amongst the different parties, and I believe there is an agreement to have next Friday's meeting be dedicated to looking at these sections of the BIA. What I suggest is that I will write a letter, and I've consulted with the clerk as well to understand what's the normal procedure in such references from other committees. What I suggest is then that I would write a letter to the chair of the Finance Committee summarizing the testimony that we've heard and on that meeting. And if any members have specific recommendations that they would like to add, I will add them in an annex to the letter that I sent the Finance Committee's chair. Is that agreeable to all? So that would be next Friday. So I see nodding at a distance in the room. That's great.
I'm good with that.
And
yes, Mr. Chair, if I may. Écoutez, c'est quand même, on est un peu en pays neuf dans ce domaine.
So, I would like to suggest that it be at least 2 meetings to cover these sections. If we can do all of it, well, it's good. I think we should have 2 sessions on it. So it's a delicate issue, and I think it would be unfortunate if we tried to do it too quickly. And if we can do it in a 1-2 hour session, that's good. But I think we should say, well, at least 2, and then we can see. Mr. Deltel, I understand the argument, but we're a bit limited in time because we have 2 meetings next week, one on Tuesday, and we've already invited the witnesses, and it would be, it's too soon for us to be able to prepare another meeting. So we just have next Friday to look at what the the BIA, and also there have been text exchanges with various parties so that we could do it on Friday, because the only thing is that we have to give them a reply before May 27th. So the only two meetings that are left will be those of next week. Well, then could we meet virtually, and then we could do that any time during the week when we're in our ridings? I don't think, after all the discussions we had, that there's a lot of appetite for this, considering that we've just been sitting for 4 weeks in a row. So I didn't feel there was a lot of interest in this, but if you would like us to vote on this, it might be possible. Are there any MPs who want to say this? Should we stay with one meeting? So, and I also want that it would be possible for those who want to send in information and recommendations. It's possible to do it. Mr. Fillmore?
And, I appreciate very much Mr. Deltel's interest in doing a very good job. We're lucky. We all have wonderful colleagues on the Finance Committee who have this study very well in hand, and I respect the work that they do, and I know that they'll do a wonderful job. They'll be going through clause by clause. We're certainly not being asked to shoulder the brunt of the BIA. It has been a long 4 weeks, and I think many of us need to give some attention to our constituents next week. If we could please keep it to one meeting on Friday and manage from there, I think that we could trust in our Finance Committee colleagues to do a really good job with the feedback that we give them from one meeting at INDU. Thanks.
Mr. Moss.
Yeah, just to be real quick, I support one meeting. It's also about interpretations, getting stuff going, and it's short notice, so there's those things going on. But I really appreciate the motion bringing forward. I think it's actually responsible, and it's a good response to another committee. And that's just my take, is that let's get this meeting done. And I appreciate the argument for two, but given everything we're doing, I think let's just try to get it one. And if we have to limit even like my time or whatever to be shortened, if we think that there's some work that needs done, I'll take a reduction of that to. If we need more time together to get it done.
And it's also that this invitation from finance is quite short notice and with short deadlines to respond. So if are we all in agreement, Mr. Deltel?
Yes. Consensus is a consensus.
Great, and I'll just take this last minute that we have to thank all of you colleagues and wish Brian a very happy birthday.
Thank you.
And we thank all of you for the great collaboration in this committee. It's been going very well. So, meeting adjourned. Brian, enjoy your birthday celebrations and have a great weekend all.